All right. Good day, everyone. And thank you for joining today's Ask Me Anything, where we answer your questions about cannabis legalization in New York. We do this every Wednesday at 4:20 p.m. New York City time. I'd like to welcome back those of you who have joined us before. And for those of you who are joining for the first time, I hope you make it a regular occurrence. My name is Jeffrey Hoffman, and I am an attorney in New York whose legal practice focuses entirely on cannabis. If you would like to contact me, you can do that either here on LinkedIn. I welcome all connection requests, or you can connect at my email address, which you see on the screen, info@420jurist.com, which I guess you might say makes me the 420 jurist. And as the 420 jurist, I will be answering your questions, roughly half of them from a list of questions I've gotten from previous Ask Me Anything sessions, and roughly half from questions which you post in the comments here today. So if you'd like to ask a question, now is the time to do it. Please post it in the comments. I do need to make a disclaimer before we get started. I am indeed an attorney, but I am not your attorney, at least not yet. Though I did notice that there are quite a few of my clients in the event today. So for you folks, please don't worry. I am indeed still your attorney. But for the rest of you, I am not your attorney. And today's event is not legal advice, does not create an attorney-client relationship, and is not a solicitation to offer legal advice. So with that, let's get to the questions. I'm going to start with a few from that both came in via email this week, as well as a few from the backlog. And one of the first ones is, where is the state at with the application process? It's an excellent question. It's one folks are asking quite a bit these days. What is exactly going on in New York? So at this time, the state has started issuing licenses for the conditional cultivation license. There's about, I believe, 144, something on the order of that number, that have already been issued, and the state is going to be issuing additional ones here in the coming weeks. It does seem that if, particularly for the outdoor farmers, if they want to get that crop in the ground and harvested before the weather gets bad here in New York, they need to do that soon. So hopefully the state is going to get the rest of those licenses out quickly. That conditional cultivator license was only available to entities which were already in the state's hemp program. So if you were cultivating hemp in the years preceding this year, you were able to go through what was I see a user just said 162 conditional cultivation licenses. Thank you for that exact number. And there will certainly be more probably in the next week or two here. But as I was saying, if you were in the hemp program, you were able to get this conditional cultivator license. Those farmers now have seed in the ground, and they are growing the first adult use cannabis crop in the history of New York State, which is pretty awesome. That crop will be harvested in October or perhaps early November, but probably mostly in October later this year. And that will be the first flower that is sold in the conditional retail dispensaries, which will be getting licensed here soon. And I think that gets us to our next point in where the state is in the application process. The conditional adult use retail dispensary license is the license that will be available exclusively to individuals who were convicted of a cannabis offense in the state of New York prior to March 31st, 2021, and can also meet several other criteria, including being able to show that they were a 10% owner of a business that was profitable for 2 years. We have just recently ended the initial public comment period for that regulation. The conditional cultivator license was drafted as a law by the legislature, so there wasn't a whole lot more to do. The Cannabis Control Board simply said, yep, this is great, we'll do a few things, and up goes the application. For the conditional adult use retail dispensary license, however, that is a proposed regulation from the Cannabis Control Board. And due to that, we have to go through a very robust regulatory review period. As I mentioned, the first 60-day period of that, where the CCB collected a huge number of comments, that ended on May 31st. We're now in what I like to call the intern. The Cannabis Control Board is going to look at all of those comments that they got and decide whether or not they need to make modifications to those regulations, or whether or not they simply want to proceed with the regulations as they were. So either way, I would say that the CCB would probably be ready to issue those licenses either middle of summer or the end of summer, depending on whether or not they want to modify the regulations. And we have to go through an additional 45-day period if they do, which is a revised rulemaking period. I'll also mention that there is a license that is available, but there is no application for it yet. At the same time that the legislature did the conditional cultivation license, they also created a conditional processor license. The Cannabis Control Board has simply not put up the application for that yet. So they could any day now. My thought is that they probably will in the next couple of weeks. I would think they would want to get those applications out of the way before they have to start dealing with applications for the conditional adult use retail dispensary license. But again, we haven't seen that yet. And my guess is that we will be seeing it in the next few weeks, if not the next month. So that gets us through the conditional licenses. The 9 standard licenses, we are still waiting for the initial draft of regulations based on those 9 standard licenses. All due respect to Tremaine Wright, she has been very busy, but she did say initially that she thought that they would have those available in late winter, then perhaps early spring. I'm looking at my calendar. I believe we are now in late spring. I believe summer starts in a little less than 2 weeks. So clearly, the Cannabis Control Board is a little bit behind on that. My hope is that within the next month, they will be releasing those draft regulations for the 9 standard licenses that we find in MRTA. We will then count 60 days from whenever those regulations appear in the state register for the initial public comment window. Much like what is happening right now for the conditional adult use retail dispensary license, the CCB will then decide whether or not they want to make any modifications. If they do, it's another 45 days. So it will roughly be 110, 120 days roughly from whenever we see those initial draft regulations as to when we will eventually get the final regulations for those standard licenses. And once that goes through, we will almost certainly see an application made available for that. I do believe that there is a roadmap for those applications being available at the end of this year or early next year. For that to happen, really everything will need to go right. The regulations need to get promulgated. There need to be minimal changes. If changes, that additional 45-day period. But if all of that goes smoothly and there aren't tremendous number of lawsuits about the regulations, which is always possible, then I do think it is possible that we will see an application for those standard licenses either late this year or early next year, and then licenses issued and businesses starting to spool up in Q1 or at worst case Q2 of next year. Again, things need to go right for that to happen. We'll keep our fingers crossed and hopefully they will go right. So that was a pretty big answer about the application, where the state is at with the application process. I did figure that it made a lot of sense for that to happen. All right, let's look at a few of the, or at least one of the questions that we're getting from online. How much of a priority is it for the state to certify compliance testing labs related to all of these issued licenses? And I would say it's a tremendous priority. There are a few of the testing labs that are open in the state that are doing testing for the medical cannabis, for the ROs, the registered organizations that are selling medical cannabis in the state. So those are already up and running. I do not believe that the number of labs that are currently up and running will be sufficient to deal with all of the cannabis that will be sold in the adult use market. We did just at the same time last week see that the Cannabis Control Board dropped proposed regulations, both for packaging and advertising. Both of those topics were handled in one document. And then there was a separate document with proposed regulations for the testing lab. So clearly, those proposed regulations made it out the door before the regulations for the 9 standard licenses that will be available in the state. So clearly that is a priority. for the CCB, and it does seem that they're going to be on track with those regulations. I'm sure that folks that are running testing labs are sending in lots and lots of comments to those proposed regulations. But we do need to get those regulations finalized and out the door so that more testing labs can open, because we certainly do not want the testing labs to be the backlog as far as getting cannabis out the door. All right, let's go to a few other questions. Actually, I had a follow-up question from a question that we addressed on last week's Ask Me Anything, so I thought that would be a great one to go into today. The question last week had to do with the delivery license and the open question of whether or not delivery license holders will be able to hold their own inventory. In some cases, delivery licensees are only able to deliver orders which come into a normal dispensary, and in other cases, there are delivery licensees where they're actually able to hold their own inventory. For those of you that tuned in last week and know that my opinion is that it really devalues the license if they're not allowed to hold their own inventory. The delivery license is one of the licenses that are to be specifically promoted to social and economic equity applicants. That is something that is specifically addressed in MRTA. And so I don't think it is in the Cannabis Control Board's best interest to devalue that license in that way. Now, I have an email from the Office of Cannabis Management. Back when they were doing their cannabis conversations, I did send an email to them asking them whether or not delivery licensees would be able to hold their own inventory. And they replied to me that, in fact, they would not be able to. Now, that reply does not have the force of law or the force of regulation. And I am hoping that there are conversations going on in the Cannabis Control Board and at the OCM about that, and that they will reconsider the opinion that they gave me in that email. Just again, because I do believe that the license is tremendously devalued if they're not able to hold their own inventory. But the question that then came in was, wouldn't it make the delivery licensee also a distributor if they have inventory? And the answer to that is no. A distributor has a very specific role in the forthcoming cannabis industry in New York. For those of you that have listened to my Ask Me Anythings before, I differentiate the licenses into upstream and downstream licenses. The upstream licenses being cultivation, processing, and distribution. So the distributor has the very specific role of doing exactly what the license says, distributing cannabis products that are created by processors to retail dispensaries and on-site consumption lounges. So that is the very specific role a distributor plays. Think of it as a wholesaler. They are effectively the cannabis wholesaler. For those of you that may be familiar with how the alcohol rules work in, I believe, pretty much every state, it's a 3-tier process where you have a brewer, a distributor, and a retailer, and you can't hold any of the other licenses if you have one of them. Very similar type of thing that we're seeing in the cannabis space, with the exception of if you're a cultivator, you can get one processing license and one distribution license of the cannabis you cultivate. Similarly, a processor could get one distribution license for the cannabis products that they process. But then when we get down to the distributor, again, they are the wholesaler. They are the go-between between the processors and the retail stores and the on-site consumption lounges. In fact, it is the distributors that will collect the potency tax or the wholesale tax on cannabis based on how much THC is in the product they are distributing. But a delivery licensee who has their own inventory is not the go-between between a processor and a retail store. A delivery driver that has their own inventory is the go-between between their own inventory and an end-use consumer. They are selling the product at retail. So that indeed is a key distinction. And for that reason, a delivery licensee is not a distributor. All right, let's go to another question that we had from previous session. Can we buy weed through the mail yet? And I believe this had to do with a discussion where people were discussing that it may be legal in Canada to get cannabis through the mail. I'm not an expert in what Canada is doing and haven't tuned into that very much, but certainly makes sense if it's federally legal in Canada, which is going to be the key aspect to this question, that they would allow it to happen through the mail. But in the United States, we certainly are not going to allow cannabis to go through the mail. The post office is a federal organization, and we're certainly not going to let cannabis go through a federal entity while it is still federally illegal. Additionally, every state typically has that have legalized cannabis have laws about cannabis not coming into the state. So that would, certainly prevent someone in California mailing it to somebody in New York. So no, you cannot buy weed through the mail yet. And frankly, I do not see that as being something in the United States that is immediately on the horizon. All right, let's go to, and I do say that someone here did mention that, yes, indeed, they do have such things in Canada. So thank you for your expertise on that. But again, not going to happen in the United States for the foreseeable future. All right, let's get to another question that came in through the comments. How can one enter the New York cannabis industry without license? All right, it just jumped there. 1 second. That's a problem if you guys keep sending in questions, but keep sending them in. How can one enter the New York cannabis industry without licensing and little capital that may not qualify? So I think I understand the question. So obviously, there are a lot of places now in the state that are selling cannabis without licensing. I do think the state is going to take a light approach on the enforcement of that until licensing is complete for stores and stores start opening and tax dollars start flowing to the state. And I do then think you will see enforcement against entities that are selling cannabis without a license, much like you would see enforcement from the state liquor authority if a store or a bar were selling alcohol without a license. As to the capital part, this is a huge issue. When you're looking at social and economic equity applicants in particular, and I do note that this question came in from the Women in Cannabis podcast folks. So I think the folks asking the question would certainly qualify as social and economic equity applicants under MRTA here in New York. The state in the law, it does say that the state is supposed to make available low or no interest loans to social and economic equity applicants that get licenses. Now, I do think ultimately it will probably be more low interest loans rather than no interest loans, although I would love it if the state made it all no interest loans for social and economic equity applicants. I think that would be a great movement on the state to really encourage those applicants to apply. Realistically, however, to be a social and economic equity applicant, you must hold 51% of the company that's going to apply for the license. Excuse me. And the reality is you're probably going to need to take investors. You can sell up to 49% of your company to investors that are interested in getting involved in cannabis in New York. So that is going to be a significant way for social and economic equity applicants to be able to raise the capital that they're going to need for their businesses. We want to be very careful about the contracts that you're going to enter into with investors. I recently participated in an exercise with Weed Week where they looked at what I would consider fairly predatory contract that an entity in California was trying to enter into with a social and economic equity license holder in California. There were things in that contract where the investor, it's actually a brand out in California, was going to be able to buy out the social and economic equity license holder for $120,000. And that is at any point. So let's say this business grew and became worth $5 million. They were going to be able to buy the equity applicant out for $120,000. That seems to me to be a pretty predatory practice. A lot of the things that I saw in some of the contracts out of California would absolutely not pass muster under MRTA here in New York, with the requirement that the social and economic equity applicant having to have a controlling interest in the business and operate day-to-day control in the business. So that's something we're going to be very vigilant about here in New York. But again, I do think for social and economic equity applicants that are lacking in the capital, there are going to be absolutely investors that are interested in investing in your business. And that, I think, is going to be one of the main channels through which applicants that do not have sufficient capital coming into the process are going to go about getting their capital. All right, let's go to a question from a previous session. What can applicants do to maximize their chances of success when obtaining municipal approval? And my guess is that that person probably is familiar with what's going on in New Jersey, where you do indeed have to get approval from the municipality where you want to open your cannabis business before you can open. Is not something that is a requirement here in New York. The only up and down vote as far as whether or not you're going to get a cannabis license in New York resides with the Cannabis Control Board. They are the ones that have the only up and down vote. Now, within MRTA, it does say that retail dispensaries and on site consumption lounges must notify a regulatory body where they're going to get their cannabis license. Here in New York City, that'll be the community board that oversees the geography where you want to open your business. And this is exactly the same process that people that want to get a liquor license must go through. You create a presentation, you go before the community board, you present to them, this is where we're going to open our store, this is how the store is going to work, this is how we're going to deal with parking issues or lines or any of the type of issues that community boards typically ask ours about when they go before them for their liquor license. And then the community board is going to be able to put in a letter with Cannabis Control Board as to whether or not the community board is favorably disposed towards the applicant. Again, the community board does not get an up or down vote. It's the exact same thing as you see with a liquor license. They get to put in a letter as to whether or not they are in favor of it or against it, but ultimately it's up to the Cannabis Control Board to make the final decision. I have seen Tremaine Wright speak a number of times about this issue, and just we don't want a cannabis store here is not a legitimate issue for a community board. It's going to need to be a complaint like the person applying has all kinds of tax delinquencies, or they were a bar owner in this community board and they play their music till 4 a.m. in the morning every night, loud in their back patio, and the police come to them all the time. Real issues that the community board is going to have to present to say they're not in favor of it, not simply we don't want a cannabis store here in our community. That will not be acceptable to the Cannabis Control Board. All right, let's see what else we can do here. And somebody did mention that mirrors the 30-day notice for liquor licenses. Yes, I do believe, and don't quote me on this, you can go look it up in MRTA, but I believe you have to notify the board at a minimum of 30 days, and it's a maximum of, I want to say 270, but that might not be right. But there's a window within which you have to notify the community board before you submit your application. All right, let's look at a few other questions here. Is it true that there will be only one individual applicant on the conditional adult use retail dispensary application? Can there be multiple equity holders in the LLC? Yes, there can be. Again, this is still a proposed regulation. We don't have the final details yet. There are some thresholds, a 51% threshold and a 30% threshold that you see for some of the holders, but there absolutely will be other participants that can participate in those licenses. Similar to what I said before, if these entities want to go out and get investors, you certainly could do that. If I remember correctly, DASNY is going to be requiring these individuals to locate in the DASNY spaces, as I'm calling them, the $200 million fund that the state is spooling up to let DASNY buy or lease property and then upfit those properties as retail dispensaries. So that is certainly going to save a tremendous amount of cost for those license applicants. Still going to need to pay DAS rent for the spaces. But of course, you're probably going to need to still raise some funding to do all the other things associated with getting your cannabis license, and of course, getting inventory and everything you're going to need to start up your store. So it does appear that it will be possible for you to get partners to sell equity stakes, but there will be thresholds for the justice involved individuals as far as the percentage of the entity that they may hold. But again, it's not that there can only be one individual that owns 100% of the entity. You absolutely will be able to partner with other folks and have that go forward. All right, let's do one or two more questions from the backlog. How does the micro business license work? All right, so the micro business is one of the special licenses in MRTA. It is one of the licenses that is to be specifically promoted to social and economic equity applicants. Um, the micro business license is the only license, other than the ROs, the registered organizations that are doing the medical cannabis. They will eventually be able to do fully vertically integrated adult use cannabis sometime way in the future. Tremaine Wright has made that very clear that they are not going to be allowed to participate in the early part of the market. So for the early part of the market, the micro business is the only licensee that will be able to be fully vertically integrated. And not only can they be fully vertically integrated, they must be fully vertically integrated. The way the law works is that whatever they do has to be of their own adult use cannabis. So that means they must grow it, they must process it, and then in the end, they're going to sell it. They can certainly distribute it to other players. It does seem that they don't have to take it all the way to the retail tier. If they wanted to grow flower and then sell it to processors, it does seem that that may be possible. If they wanted to process it and then sell it to distributors, that may be possible. But they are certainly going to have to grow it. Most of the micro business folks are going to be, I think, interested in retail. There's a reason why so many people want to be vertically integrated, because it gives you information all the way from seed to sale. And so that is a benefit that the micro businesses are certainly going to have. Now, the micro businesses will certainly have some types of limitations, whether or not it's canopy size or square feet of grow or size of your retail presence. If you have one, perhaps a limit on number of employees. We don't know what those limitations on the micro business are yet. That is something we will see in the regulations, which will be forthcoming from the Cannabis Control Board. There certainly will be some regulations, but we don't know what those are yet. All right. Let's do one more question from the backlog, and I think that'll wrap it up from the day. Are there any proposed packaging requirements that have been released yet? Which states would they be similar to? So I'm a New York attorney, so I am not going to speak to similarity to other states. But yes, indeed, there are proposed packaging requirements. If you go to the Office of Cannabis Management's website, you will indeed be able to find the proposed regulations, which they just dropped last week. For packaging, those are regulations for both packaging and advertising. They put them all into one document. And just some very interesting packaging requirements. I think fairly similar to what you have seen in other states, as far as things about what the packaging can and can't do. Now, I do think that this initial round of proposals from the Cannabis Control Board is a bit more stringent. They are very stringent on the types of fonts you can use. They actually itemize the types of fonts that they want to allow you to use. They don't want a lot of the more playful fonts that may be appealing to children. Very draconian about, not bright and crazy colors, and they don't want, everyone has seen the Lifesavers gummy bag and how there are cannabis brands that are doing edibles that look just like the Lifesavers cannabis bag. Clearly, the Cannabis Control Board is not going to allow that. The branding for dispensaries is mostly going to be on the exit bag. So you can take the cannabis product that you got from the distributor, which I don't believe the retail dispensary is going to be able to modify. You can drop that into what is being called the exit bag, very similar to other states. And the dispensary will be able to put their logo and perhaps their contact information on that exit bag. So a little bit of branding allowed on the part of the dispensary there. I would describe these initial regulations as vaguely draconian. All of you packagers and processors out there. I was at the big cannabis show at the Javits Center talking with some of the packaging folks there, and you guys have your work cut out for you. So that regulation is out. A proposed regulation is out. It's got to get into the state register before we start counting the 60 days for the public comment window. As soon as it's in the state register, you'll be able to submit comments to the Cannabis Control Board. And if you're part of a packaging company, I would suggest you get on it because they're really draconian right now in the proposed reg about what you guys are going to be able to do. So if you want to see something different, now is going to be your time to speak, or at least in the near term, hold your peace. All right, we've hit 4:50, and I've got a client meeting at 5, so I've got to get out of here. I want to thank everyone for joining us here today. For those of you questions that didn't answer, thank you for submitting them. We will hold them over to a future session. I just want to say, again, thank you everyone for participating. We do this every Wednesday at 4:20 New York City time. As I mentioned at the top of the show, if you're not currently a connection of mine on LinkedIn, please send me a connection request. I welcome all connection requests. And as I say each week, I know we're all incredibly excited that there's going to be an adult use cannabis industry here in the state of New York. There's probably no one more excited about it than me. That being said, the most important thing that happened in MRTA, the cannabis law, is that folks are now able to expunge their previous convictions for cannabis. Folks do not have to check the yes box on job or housing applications. The question, have you ever been convicted of a crime? Which, if you check the yes box, usually means you don't get that job or that housing. So folks no longer have to do that. A lot of jobs, or most jobs in the state now, can no longer be drug tested for cannabis. And we got to get all of the nonviolent cannabis offenders out of jail. For a state to profit from an activity for which it is incarcerating people is a crime against humanity. And all of the nonviolent cannabis offenders, they have to come home. We've got to bring them home. I'm going to be doing a lot more about that you're going to be hearing about in the coming weeks and months, but they all must come home. It is unacceptable for the state of New York to keep nonviolent cannabis offenders in jail while the state of New York is about to profit. They already are a little bit from the medical cannabis, but the state of New York is about to profit tremendously from the adult use cannabis, and we got to bring all of those nonviolent cannabis offenders home. Thank you for joining me. Enjoy the rest of your day. Have a good one.